Bhagavatam Rao, who's being referred to as the boss here.
Yeah.
And other participants. The subject of this session is supposed to be the MOP letters on operationalizing open access, legal interpretation and operational implications. Now, that's fairly wide because if you have to concentrate only on the Ministry of Power letter, I think it's really a waste of time. But I'll try to address a few issues that arise from the Ministry of Power's letter and also on the issues that deal with the operationalization of open access as it should have been. So far as the Ministry of Power letter is concerned, I have seen it's supposed to be based on an opinion of the Attorney General, which, with great respect in my opinion, is completely uncalled for. In fact, the Solicitor General had given an opinion earlier, which I think was the correct position in law. What the Ministry of Power's letter, and which I am told there is now a second letter, which says that we reiterate and we want this done in the sense. What it aims at is, it says all those who have demand over 1 megawatt will automatically become open access consumers, deemed to be so. They now will have no regulated tariff from the distribution company. All their power purchases must necessarily, whether it's from the distribution company or from any other source, must necessarily be on a negotiated basis, and it's not regulated by the regulator. According to me, it's a completely wrong interpretation of the law, and I think more or less that is the fate it has come to. It is virtually a non-issue at the moment, though a lot of people are talking about it. If you look at the way in which the entire Ministry of Power letter has come, it seems to have been some excessive efforts by certain categories of stakeholders to try to get perhaps more than what is their due. Maybe it's the exchanges, maybe it's the power producers, but it is entirely out. I don't think it will ever be sustainable in law. My advice to everybody is ignore the Ministry of Power letter, because that is all it deserves to be. Now going down to the other aspect, the question of operationalization of open access. Open access is supposed to be a means to make a choice. The obligation of the distribution licensees, that is the universal service obligation, is not disturbed. That remains as it is. That's a condition of the distribution licensee's license. That remains undisturbed. Now the question is, are you giving the consumers an option? There's a law intent that the consumers must have an option that they can go and buy from anybody else, not necessarily from the distribution license. That is the issue which needs to be addressed. Clearly the law says, once open access is introduced, then the consumer has the choice. He can go anywhere else. It also says that that choice is exercisable at a cost, at an additional cost. That cost is the cross-subsidy surcharge which they will have to pay when they avail open access. Now the question is this. Over the period of time, let me tell you how that fifth proviso of the section 42(2) actually came about. Originally, as it stood in when the Electricity Act was passed, it was left to the commissions to decide when at all they should introduce open access, and if they could decide, never to do it. That was that kind of discretion with the regulator existing in the bill as it was introduced in the Rajya Sabha. When it was being passed in the Rajya Sabha, an issue was raised in the Rajya Sabha saying that how do you leave this if open access is supposed to be one of the central themes of this reform process? Then can the regulators be left to never introduce it? Or is that discretion to be subject to certain mandates? An assurance was given to the Rajya Sabha that an amendment would be brought in to provide for it, and that is how subsequently by an amendment this 1 megawatt thing is done. What it says is that within 5 years from 10th June 2003, the commissions have to introduce open access for at least 1 megawatt and above. It was a time frame for operationalization. If that time frame was there, the question which I put is it now possible for the regulator, because he is compelled to introduce, because the regulator is compelled to introduce, and for some reason the regulators, whether because of issues of regulatory capture or whether reasons of their own regulatory philosophy or policy, which may be at variance with what the objects of the acts are, in their own thinking of the matter, can they introduce the open access as required by the Act and at the same time set up embargoes against it in other ways? This is precisely what seems to have happened. Not here only, but all over the country. Because they are compelled to introduce open access within that 5 years, regulators have introduced it. But side by side, they have set up what in all free trade considerations would be considered as impermissible embargoes. Embargoes of the nature of setting up a regulatory methodology in which it will be difficult for you to actually secure open access. Second, not exercising adequate oversight or not enforcing, not taking any enforcement action against the wire companies, whether it's the transmission or the distribution companies, to ensure that even the regulations are observed. If I see the problems that were raised this morning, which Mr. Haridol kept saying, just write a letter to the regulator, I don't think things work like that. First, I see it as the regulator's responsibility to regulate. It's for the regulator to say that is the regulation that I put in and the law that I put in, is it being observed by the DISCOMs? It can't be said, I think the DISCOMs will follow it. I'm sure the DISCOMs will follow it. That's not the approach of a regulator. Or it's not the approach of a regulator that only when a formal complaint is made, a formal proceeding is launched so far as enforcement of regulations and the law is concerned. Frankly, not only in Andhra Pradesh, but all over the country, the regulators have failed. I think there's only one or two regulators where I have known where they have gone proactively and said, report to me as to how you are complying with this regulation, and enforced it. Now, for example, take an SLDC letter. There is always a time window. To get an SLDC, no objection. The word NOC is something from our feudal past. This word NOC, for everything we need an NOC. It's not NOC, no objection. It's a question of taking notice of my demand to access and confirming that there is only one reason why you can refuse, and that is the lack of transmission and distribution capacity. It's a right which is defeasible for only one and only one reason. Practically, there may be one more reason, and that is whether an adequate metering facility to be able to quantify the amounts of energy that have gone into open access. That's practically perhaps the only other reason. If these two reasons are non-existent, there is no choice. So first, if I made an application and the transmission or the distribution entity does not communicate that it has a transmission or distribution capacity problem within a fixed time frame, then it must be allowed. In other words, the SLDC itself must say, no objections, clear. It must clear by itself.
Yes.
The only thing that can defeat it is the absence of transmission or distribution capacity. At a distribution company's level, that means that when somebody is accessing the state's transmission and distribution systems, to go into interstate transactions, when they are getting power from somebody else, there is an SLDC, then there is an RLDC, and you will have to go through both the stages. You actually apply to the RLDC, and the RLDC will notify the SLDC. The CERC had set out a set of regulations. It became a subject matter of dispute that where the CERC, under the CERC regulation, if an application for open access was made within the time window for the next month that was specified, and if the SLDC did not respond with a transmission complaint, transmission difficulty constraint, then it had to be given. Now in this game of certain states, I would say that particular case in which I was involved in, and Sanjay was also in another case at the time, the state didn't want the energy to go out from its own state. The state utilities decided to block it. They blocked it. It compelled the generator's capacity to be stranded. The generator then had no other option but to commit himself to the local state entity at whatever price that would be offered. Otherwise, his capacity is stranded. Capacity contracted for interstate supply is defeated by a state non-response. The matter carried to CERC, of course there were interim orders, give them open access, clear it, all this was done. They refused to comply. They refused to comply, the matter was heard in an urgent way, all this happened. Finally, the regulator sat over it for the next 6 months. Delivered a verdict at the end of 6 months, saying what? Since the period for which the Open Access Act application has now lapsed, this proceeding has become infructuous. This is the manner in which of regulatory performance. a situation which has arisen all over the world, wherever these commissions are from, we are trying to ape or, not instead of learning from, we are trying to ape systems which started evolving in the US and then brought over here. One issue which to a large extent remained unanswered there is of greater relevance here. To whom is the regulator accountable? And in what way is the regulator accountable? For not doing something which the regulator ought to do? Take for example in Andhra Pradesh. Power shortage has been there for the last 2 years. Over the last 2 years, consumers have been told by DISCOMs at their own sweet will and pleasure, shut down now, stop now. Don't take power from 6 o'clock. All by themselves. Not for 1 day's system emergency, not from a short-term 2-3 day system emergency situation, but to say there is a shortage of power, we will not supply you, shut up. People have been given letters, from tomorrow onwards you will not be allowed. Regulators, with great respect, I am on a criticism, not for the sake of criticism, but I am on criticism for the sake of evoking a proactive approach to these problems. Regulator never passed an order. Never passed an order. The regulators never passed an order as to how this should be regulated. Each local SE became a master unto himself, saying, you do this, you don't do this. If you don't do this, I'll cut off. And to the extent that even if during that period, if somebody had already arrangements through open access or otherwise for other power, they said you don't use that power also. We will not allow you to use power which you have contracted from somebody else. That also you have to stop. So what will you do with that power? That we take. This is the situation, and during this entire situation, it is a matter of regret that the regulators did not act. It is only in this year, and after there was much, somewhat nearly agitational situations, that the regulator for the remainder of this year passed an order. In other words, there is a regulatory non-advertence, regulatory failure in this whole thing. Now, if this is the kind of thing that is happening, then appeals to the regulator get nothing. Unless you do it as a storming of the bastion. You have to go in there, 4 or 5 people, 6 people, give me an appointment now, stand outside the office, then perhaps maybe something may move. But that's not the way a regulated system is supposed to work. Why I am saying this is, when we talk of operationalization of something under a regulated scheme, it requires that regulatory activity is not merely the making of regulations, but also enforcing it and seeing whether the regulations are working, how they are working. If there was a mention of 100 kilowatt people and so on and so on, they are entitled to open access. Do you think even an application will be entertained today? It's scotched. It's scotched then and there. But the regulations allow it. The regulators will not act. That SLDC permissions are given in routine promptly is a statement made here. Everybody knows that's not so. experience of everyone doesn't percolate down to the regulatory mechanism, then it becomes a difficult proposition because you have nowhere else to run other than lock the doors of the court through people like me, eventually, and you get this order, that order, something happens, and nobody knows really what is possible and what is not possible. Having said this, what is it that needs to be done? More particularly in a situation where there are great shortages, the needs of different kinds of industries are different. The needs of different kinds of industries are different. And the times at which they require power, or the way in which they need the extra power is different. First, everybody ought to know what the regulations are. Second, the regulator must know that there are regulations in existence. Third, the regulator must enforce its regulation because the regulator is there to regulate first and foremost the distribution licensee and everything else in that context. Fifth, what are the remedies available to people to whom the regulations are not observed? For example, you make an application. The application must be processed within 1 day, 2 days, whatever the regulation is. If it is not done, what is the remedy? There is no remedy provided by the regulation or by the regulator. If you go to the regulator, they will say, please pay 5,000 rupees fees, file a petition, I will number it after 2.5 months, and I will bring it for hearing after 3 months. That is the way the regulatory process works. And this is the unfortunate state of affairs. Things of this kind are life situations. They require a mechanism by which there is a peremptory and immediate recourse available and a remedy available. It cannot wait for a formal process of petition, counter, hearing. It cannot wait. It has to be dealt with. If something has not been complied with, in that time window, if you delay that, somebody else has walked in and taken it away. And if you don't have a proper regulatory system, and I'm saying we are not very far from this happening, there will be situations where there will be unhealthy practices of blocking X so that I can get the transmission capacity. This kind of practices will develop. And we are fertile ground for it, as we have seen in so many of our cases. You block somebody so that somebody else will get the priority. And all these, the unhealthy practices that follow this will come, whether it is in the state grid, which is of a lesser dimension, but on the central grid, it is of a larger dimension. On the main national grid, it is of a larger dimension. The next set of things is remove artificial tariff embargoes. If one studies the purchase pattern in Andhra Pradesh, the top actual purchases during this period, 20% of the most expensive power result in a negative cross subsidy to the DISCOM. In other words, if the DISCOM buys at anything more than 4 rupees per unit, then leave alone getting cross subsidy. It is getting other consumers to cross subsidize. It is actually losing money. There is no cross subsidy element involved in it. That has been demonstrated. if you don't have uh, 20 minutes. If you don't have on the power purchases that are made at this level, so there is a question of a cross-subsidy surcharge. We are talking for hats. If you reduce it, the others get a real option. Now there was a talk, you said you want it in the short term or you want it in the medium term. You may have a short term restriction, but a viable alternative I can get only if I make a medium term contract. That's possible. Now if a medium term contract means that I should not be penalized now in case there is a sudden drop in demand or there is a change of weather or there is a idle comes on for a short period, and at that time you say temporarily I am lifting the restriction and control. Cross-subsidy surcharge will now apply in full force, and cross-subsidy surcharge is anything up to 160, 170, 2 rupees per unit. It makes the entire sourcing of energy uncertain and improper. So this regulatory barrier, once you allow open access, you must allow it to function. This is what operationalization of open access requires. It requires freeing up the ability to access the open access system. It requires the removal of trade barriers beyond what is reasonable and what maintains a competitive position. That is, maintains a viable position. You have to have that in mind, that if the cross-subsidy surcharge, let us say, is over 30 paisa or 40 paisa or something like that, at that stage, it is not a viable option. And therefore, to say that I am giving over access itself is really an illusion. This is the requirement. Ministry of Power, please ignore. I don't think it's going anywhere. So far as operationalization is concerned, it requires a regulatory approach, and it's only under such a regulatory approach that the consumers will be able to really exercise options. Thank you. If there are any further questions,
Thank you very much, Mr. Chaudhary.